A man worked for 30 years, saved $400,000 in his company, 401k. He got divorced. He started a new life. He had kids who loved him. And when he died, every single dollar went to his ex-wife. Not his kids, not his new partner, his ex-wife, a woman he hadn't spoken to in years. His family sued. They went all the way to the Supreme Court. They lost because of one form he forgot to update after his divorce. That case is Egelhoff v. Egelhoff, decided in 2001. And the law that handed his ex-wife that money is still active right now, today, probably sitting in your HR portal under a tab you haven't clicked in years. Today, we're gonna walk through exactly what happens to your money when you die. And I promise you, almost everything you think you know is wrong. Here's how bad the situation actually is. 56% of Americans have zero estate plan. Zero. No will, no trust, nothing. Only 24% have a valid will. And here's the kicker. Even those people, most of them think a will is going to protect their family. It's not. Not even close. We'll get to that in a second. Right now, there is $84 trillion sitting in the accounts and homes of aging baby boomers about to transfer to the next generation. And the majority of those families have no idea how the rules actually work. So let's fix that. 4 traps, 4 solutions. Let's go. Problem 1. Your will is a ticket to court. Let me ask you something. Why do you want a will? Most people say, so my family doesn't have to go to court. That's the single most common answer, and it's completely backwards. A will does not avoid probate. A will is specifically designed to go through probate. It is a letter of instructions to a judge. The executor takes your will, files it with the court, and then nothing moves until a judge says so. We're talking 6 months minimum, frequently 1 to 2 years. All of your individually held bank accounts, frozen the moment the bank is notified of your death. Your family can't touch them. And because probate is a court process, it's also public record. Anyone, your nosy neighbor, your estranged cousin, a predatory creditor, can look up exactly what you owned, what you owed, and who gets what. In California and Florida, attorney fees in probate are calculated on the gross value of the estate, not the net. Meaning, if you own a house worth $500,000 with a $450,000 mortgage, the attorney fees are based on the $500,000. Your estate pays thousands in fees on a house your family barely breaks even on. A will is better than nothing. But it is not the protection people think it is. So what actually works? 3 things. And you can set all 3 up without an attorney, often in the same afternoon. Number 1, beneficiary designations. Bank accounts can be set up as payable on death. Investment accounts use transfer on death. You name a person. When you die, they walk into the bank with a death certificate and an ID, and the money is in their hands within days. No court, no judge, no fees. It completely bypasses probate by contract law. Number 2, joint tenancy with right of survivorship. Property or accounts held jointly under this title transfer automatically to the surviving owner the moment you die. No filing required. The survivor records a death certificate and takes ownership. Done. Number 3, a revocable living trust. This is the gold standard for anyone with a house, significant assets, or privacy concerns. You transfer your assets into the trust while you're alive. You still control everything, you're the trustee. When you die, your successor trustee takes over immediately, distributes assets privately, and your family never sees the inside of a courtroom. One family in the research we reviewed had a home, a vacation property, and $500,000 in brokerage accounts. They put everything in a living trust. Their assets were fully distributed within 3 weeks of death. Private, no fees, no court, 3 weeks. Contrast that with Prince. Problem 2, the ex-spouse trap ERISA. Prince Rogers Nelson died in 2016 without a will. $156 million estate. 6 years of court battles. Nearly half of it consumed by IRS estate taxes, legal fees, and administrative costs. That's a famous case, but there's a version of it that's even more financially devastating, and it happens to ordinary people every day. Here's the trap. When you start a job, and enroll in your company's 401k. You fill out a beneficiary form. You name your spouse. Makes sense. Then you get divorced. You move on. Maybe you remarry. Maybe you update your will. Maybe you even get a court order as part of your divorce settlement that says your ex is entitled to nothing. But you forget to update the beneficiary form on your 401k. You die. Your ex-spouse gets every dollar. Your will is irrelevant. Your divorce decree is irrelevant. Your new marriage is irrelevant. This is because employer-sponsored retirement plans 401ks, 403bs, most company pension plans and life insurance policies are governed by a federal law called ERISA. And under ERISA, the plan administrator is legally required to pay whoever is listed on that form, full stop. Many states have laws saying divorce automatically revokes ex-spouse beneficiary designations. ERISA overrides those state laws entirely. The Supreme Court confirmed this in Egelhoff v. Egelhoff. The ex-wife got $46,000 in life insurance and pension benefits over the objections of the biological children. The court said, the form controls. Here's what makes this even more dangerous. It's not just 401ks. It applies to any employer-sponsored plan, company-provided life insurance, pension plans, health savings accounts with death benefits. If your name change, your divorce, your new family isn't reflected on those specific federal forms, the old name wins. This is fixable, completely fixable, but it requires you to actually do it. Right now, after this video, log into your HR portal, find every employer-sponsored account, check the beneficiary, update it. Then do the same for your IRAs, your brokerage accounts, and your life insurance policies. This is not a one-time task. Every major life event, marriage, divorce, birth of a child, death of a beneficiary, requires you to revisit these forms. And here's one more wrinkle on retirement accounts that most people don't know about. Under the Secure Act and the final IRS regulations that took effect in January 2025, most non-spouse beneficiaries, your adult kids, your siblings now have only 10 years to drain an inherited IRA after your death. Every dollar comes out as taxable income to them, potentially hitting the highest federal tax bracket. Miss a required minimum distribution during that 1-0-year window, 25% IRS penalty on the amount you should have withdrawn. That's not a typo. The fix here involves talking to a financial planner about Roth conversions, or using structures like charitable remainder trusts to absorb some of that tax liability. But step one always is making sure the right person is named on the form. Problem 3, the helpful joint account that can wreck everything. Here's a scenario that plays out in thousands of families every year. Mom is getting older. She wants her daughter Sarah to help manage bills, make deposits, keep the lights on. Simple. So mom adds Sarah's name to the checking account, checking the box at the bank that says joint account with right of survivorship. Easy solution. Except a few things happen that mom never anticipated. Sarah gets divorced. Her husband's attorney finds out she's a co-owner of a $120,000 joint account. It gets pulled into the divorce proceedings, or Sarah gets sued. A creditor places a lien on the account. Mom's $120,000 is now frozen. Or mom dies, and Sarah automatically inherits the entire balance, completely cutting out mom's other 3 children who get nothing because the account transferred by operation of law. Or worse, Sarah predeceases mom. The account goes into Sarah's estate, tangling mom's money in Sarah's probate. All of this from checking one box at the bank. And here's the legal dimension most people have no idea about. When you check joint account with right of survivorship, you've created a legal presumption in most states that the survivor gets everything. Your will cannot override this. Your stated intentions cannot override this. The box controls. The only way to fight it after the fact is in court, and the standard of proof is extremely high. You'd need clear and convincing evidence that the account was only meant as a convenience account, where one person manages funds on behalf of another without any survivorship rights. Some courts allow it, many don't. The fix is simple, free, and available at every bank. Instead of adding Sarah as a joint owner, Mom designates Sarah as the payable on death beneficiary, POD. During Mom's lifetime, Sarah has zero access to the account, zero ownership, zero liability exposure. If Sarah gets divorced or sued, that money is completely untouchable because it still belongs entirely to Mom. When Mom dies, Sarah presents a death certificate, claims the funds within days, and the account is distributed exactly as intended, without court, without probate, without accidentally disinheriting Mom's other children. No joint ownership, no survivorship trap, no exposed assets. Same result, Sarah gets the money. Completely different risk profile. All right, one more thing, and this one is genuinely one of the most useful things you'll hear today. When a parent dies and leaves a home to their children, most people assume the kids need to refinance the mortgage, get their own loan, qualify all over again. At current rates, that could mean going from a 3% mortgage to a 7% mortgage instantly. That's wrong. There is a federal law called the Garn-St Germain Depository Institutions Act of 1982. Under this law, if you inherit a residential property with fewer than 5 units from a relative, the lender cannot enforce the due on sale clause in the mortgage. That's the clause that normally lets the bank demand full repayment when the property changes hands, which means you can inherit the house and simply assume the existing mortgage. Keep the original rate. Keep the original terms. No refinancing required. In today's interest rate environment, for a family inheriting a home with a low rate mortgage from a few years ago, this is worth tens of thousands of dollars over the life of the loan. Most heirs, and frankly, most real estate agents, have no idea this law exists. Let me give you the takeaway in under a minute. A will is not a plan. It's a court filing. If you want your family to actually receive your money quickly and privately, you need beneficiary designations on every account, POD and TOD wherever available, and a living trust for any real estate. Your employer-sponsored retirement accounts and life insurance are governed by federal law. Your will cannot override them. Update the beneficiary forms today after every marriage, divorce, and major life event. Never add a family member as a joint account owner just to help with bills. Use POD instead. It gives you the same result without the legal exposure. And if you inherit a home, don't refinance before you talk to an attorney. Garn-St Germain may let you keep that mortgage exactly as it is. 76% of this country is completely unprepared for this. Now you're not. If you want the exact checklist, every form you need to review before you leave today, it's in the description below. And if this video changed how you think about even one account you own, share it with one person who needs to hear it. It might be the most valuable thing you do for your family this year.